All right, I'm Gary Smith, and with me today, Los Angeles Magazine writer Michele McPhee and criminal defense attorney Kimberly Casper. Guys, welcome. Thank you for joining me.
Thanks, Gary.
So I believe you guys both watched the opening statements in the second trial of Karen Read, which kicked off today in Boston. Let's start with just opening thoughts. What stood out to you guys as, maybe the same or maybe different from the first trial?
I think there was, well, first of all, we started out with a brand new prosecutor. His name is Hank Brennan. He is well known in Boston, and you might hear from my accent that is my hometown. Hank Brennan famously represented James Whitey Bulger, the notorious Boston gangster who was on the FBI's payroll for a decade before he took off and went on the lam for more than a decade and was finally found at a hideout in Santa Monica, not too far from where I'm sitting right now. So Hank Brennan is a mob lawyer. And I think that it was, this is a new process to see somebody who's been in the defense world for a long time be hired. And Kimberly can certainly speak to this. It's very unusual that a DA's office goes to the outside and into the private sector to hire a prosecutor to present this case.
Yeah, Kimberly, how often do you see that type of thing where someone from the defense world is brought in to work for the prosecution?
Well, I think first off, a lot of defense people, that's not their natural instinct to flip that way. I think it's typically the opposite that we see. But I also think it's interesting on the defense side there that they have a juror from the first trial too. So that's a bit of an interesting twist as well. I think it'll be something to see.
The juror that you're referencing was a alternate, if memory serves, in the first trial, and also an attorney, and she has since been brought on to the defense team led by Alan Jackson. Is that correct?
That's correct. I mean, I've never seen this before, ever. You have somebody who is an alternate, who sat through all of the evidence and felt so strongly that Karen Read was innocent that she said she wouldn't be able to live with herself if she didn't try to help. So that's something that's going to, I think, be a hindrance. And I think you probably agree, Kimberly, to the prosecution, when you have somebody who said, I sat through the first trial and you didn't get it. Now we're sitting here and listening to the same argument again. I definitely think that's going to be a challenge for the Norfolk County District Attorney's Office.
Yeah, I definitely think if that's not compelling, I mean, it's hard enough to have these kind of big media, nationally recognized jury trials where I'm sure jury selection was impossible, even finding people who wouldn't be some bias, wouldn't know about the case or hear about it. And to have somebody who lived it and breathed it coming in, it'll just be interesting to watch. And it was kind of shocking to watch today, the opening statements. The prosecution was giving the same kind of position that they did the last trial. All they really offered was, I think, the most significant new thing I thought they mentioned was we have a neurosurgeon who can now confirm that his head was hit, and now they have kind of a theory of the cause of death that they couldn't really prove before. It's really.
Did you find it interesting that, Hank Brennan started his case by saying he got out of the car, he walked a few steps, he read a text message, then he fell down? But that's the first time I had heard that evidence, that he was moving around outside of the car. And I think that this is a way for the state to provide an explanation to the steps that we heard about in the first trial. I don't recall that information, that he actually read a text outside in the cold and then he just laid down and died. I think that was a new factoid that I hadn't heard before.
Yeah, I think it's kind of what I was telling you this morning, that with this second trial, the prosecution kind of gets to tighten up on their theories and kind of cut the fat on what wasn't really working for them. I think during their opening today, they kind of just stressed, the science and the facts and the evidence, and the defense has that too. So I think it's just going to be a battle of, cell phone pings and who can have the most compelling story from that.
Well, I thought it interesting too that Alan Jackson, he was the one that was screaming cover up, cover up, cover up. He did not mention the word cover up once. He just kept repeating this phrase: there was no collision. there was no collision. So if the state's argument is that she backed into him with her SUV while drunk and there was no collision, and he claims that the evidence will support that, it's a completely different argument that they had the first time, which is, this was a case of government misconduct. Now, I think both can be true. I mean, as he's already pointed out, that the lead investigator in this case, Michael Proctor, has been fired. He pointed out how difficult, and I can attest to this as a longtime journalist who worked in the Boston area, it's really difficult to fire somebody from the Massachusetts State Police. And he also pointed out Proctor's obvious conflicts of interest by knowing the Albert family so intimately.
Michelle, it's interesting you bring up Proctor. I wanted to ask about that. Michael Proctor was somebody that was spoken about a lot by Alan Jackson in the defense's opening, but it was a name that was not brought up once in the prosecution's opening. I wonder, Kimberly, did you have thoughts on that? You would think, one might think that the prosecution might at least make light of that so that they can't be whacked with it so hard by the defense, but they just elected not to reference him whatsoever. He was the lead investigator who has since been dismissed and reprimanded for some of his conduct.
I mean, I didn't find it too shocking that they want to, leave that out, or leave out bad evidence that was so kind of damaging in the first trial, or just, kind of shocking. I think they're probably going to use the first trial as a roadmap of what to try not to bring in and what to try to exclude. And so they're probably going to, stick to more theories like phone pinging and steps and things that you don't have to talk to a witness for, really.
Yeah, I also found it somewhat interesting in the defense's theory of the case. They, kept talking about how there was no bruising and no, damage from being struck by a vehicle. Yet their theory seems to hinge on the idea that he was beaten up by, multiple people and then left for dead in the cold. I don't exactly see how they're going to square that circle.
Well, it's interesting because I really did take note of how many times Alan Jackson brought up the fact that he died in a warm place because there is no hypothermia, and it was carried to a cold place. And he also cited that there was no evidence, there was no DNA evidence found on any of the 46 pieces of glass that were recovered at the scene well after the fact, I think the defense is going to point out. But there was DNA from 5 unidentified males found on his shoe. Now, I guess you could argue he walked around, he was in a bar, it was crowded, who knows? But I think that's going to be a tough nut for the state to square away with.
Yeah, and you mentioned the 46 shards of purported taillight that they found. I think the defense also pointed out that those were discovered after 2 searches of the area, and it was only, in a third search that those were discovered and collected, and then there was no DNA evidence on any of them, despite the fact that the prosecution's theory is that, that struck his arm and lacerated his arm. So presumably there would be some sort of, DNA evidence of one form or another that would be at least on some of those pieces. Is that correct?
I think Alan Jackson made a point of saying that those pieces of taillight, like the dozens of pieces, were found after Proctor took over the crime scene, and when he had access to all of the evidence and the exhibits, which included her vehicle. So I think creating that timeline, a TikTok, if you will, of exactly what steps were taken in the evidence collection is going to definitely help the defense in this case, especially given that the lead investigator is most certainly not going to be put on the stand, because then he will be forced to read those outrageously misogynistic text messages that he wrote not only to family, which is outrageous, but to his supervisors, where he called this woman, this suspect that he had just arrested, a name that most of us wouldn't utter out loud. He said the inside thoughts out loud, and it wasn't very nice inside thoughts, that's for sure. And the fact that he was looking for nudes in her phone, this is all wildly unprofessional behavior that is going to speak to the defense's argument that, look, whether she did it or not, and this is something, Kimberly, you and I talked about this morning. You can't say this woman was so drunk she was in a blackout, but also say she was so calculated she started her cover up when she started calling John O'Keefe's phone 500 times. So I think there's a little discrepancy there because, we heard Hank Brennan say, She was wildly intoxicated. She had 8 drinks in the span of an hour. But at 1 a.m., she started in an angry rage calling John O'Keefe, her boyfriend's phone, and yelling at him. And that's where I was struck by this. That's where the cover-up began. And you can't have it both ways. The woman can't be in a blackout and then cognizant enough to create a cover-up story in her head at 1 a.m.
Yeah, Kimberly, based on the opening, do you see any large deviations from the defense, or do you believe that they're going to largely go down the same road that they went in the first trial and just aim for the same reasonable doubt that they were able to procure in at least enough jurors' minds to end in a result of a hung jury?
I mean, for the defense, first, it's unfortunate that the jurors didn't get on the record that they, unanimously didn't find for murder in the first trial. Was that? Yeah, that's just unfortunate. I think, it's something that was working. It's something that was very clearly evident, and I think that's why Alan Jackson was really emphasizing there was no signs of hypothermia. This was. He died in a warm place. Where possibly could that be but in the home? And he even said that, I think, during his opening today, that the data will unequivocally establish that John went into the home that night. And then bringing up that the impact on John O'Keefe's head was from a raised or fledged surface, and that does not exist at all on the Albert's lawn. So I think that it works. I don't know how the jury concluded how they did in the last trial, but it's kind of a no-brainer to me.
Yeah, absolutely. And the evidence that they were using in the first trial to establish that he had entered the home and gone up and down different levels, I believe, was that from a smartwatch device that he was wearing? Is that how did they? Do you remember how they established that?
Yeah, Michelle and I were talking about this morning. Do you want to?
No, go ahead, Kimberly.
Yeah, I think it was from an Apple Watch, but Michelle was saying that during the opening today, they didn't reference it. So I guess that was a bit of a deviation. Not really sure why, but I think maybe they were, working with different angles, like the absence of hypothermia, of the absence of him dying in the cold. I mean, I don't think anybody can say that they didn't hear something about the first trial and didn't hear those first theories that kind of hit home and that could be proven. So I think, both sides got the benefit of time in preparing for this trial and to get, more forensics onto all the electronic data that they have and to get more calculated and to, really focus in on those more nuanced theories.
Yep, absolutely.
People outside, Gary, people outside of Massachusetts are going to think, wait a minute. So the lead detective has a babysitter that's in the Albert family. Everybody knows everybody. The brother is a cop. The brother is a selectman. Full disclosure, I've known Brian Albert for years as a reporter working in Boston because he was a high-profile Boston police officer and one who was involved in a lot of high-profile media cases. So everybody knows everybody in Boston. If you live in a town like Canton, Massachusetts, it's not unusual that you know every single person in the case. But when even me, being from Boston, listening to that today, it's like, wait a minute. The EMT is buddies, best friends with the daughter of the Alberts. This seems very incestuous. And it speaks very dramatically, I think, to the DA's decision to not have a lot of these cops just recuse themselves in a case as critical as the death of a Boston police officer in a blizzard. Certainly the DA should have taken a look and said, okay, guy, you're off. You're friends with the Alberts. Let's bring in some outside people that work up in the North Shore of Massachusetts, where you don't know everybody. You have to remember the CPAC unit, these troopers work very closely with the local cops, which is why you heard testimony in the first trial about how Michael Proctor and Kevin Albert, who's a Canton police detective, went out and got banged up in Proctor's cruiser, so dramatically drunk, and it feels like everybody in this case has some sort of hint of that, that Kevin Albert left his badge in Michael Proctor's cruiser. Like, this is how close these relationships are. These troopers work with these local cops day in and day out on these cases. This absolutely, Michael Morrissey, the district attorney of Norfolk County, should have brought in a fresh face, a fresh group of CPAC guys that worked in an agency far north of Canton, Massachusetts, which is very small town cop land right out of the Sylvester Stallone movie.
Yep, absolutely. All right. Well, we're going to be watching the case carefully. Any final thoughts before we go?
Well, just to add to what Michelle was saying, I just think it's so crazy and bizarre that, an officer died on another officer's lawn. You would think they would have taken that investigation so seriously and to have made it so airtight with the chain of custody, with the evidence, with their entire investigation, to make it as thorough as possible to exclude any implication that another police officer could be involved. So just the fact that, evidence was carried in red Solo cups, the things were missing for hours and not documented, taillights were showing up hours later after the car was already, possessed. To say that all the officers there were a bit too comfortable, I don't know. It's just
that's putting it mildly, I would say.
Extremely mildly.
Yeah.
I'm trying to give it the benefit of the doubt, but I can't.
I'm more cynical than you are, so I'll go ahead and just throw it out there for you. It can really take you off the hook a little bit.
It's the whole defense flipping to prosecution. Can't do it. Don't understand that person. Totally.
Well, thank you guys both very much for your time. We'll be watching carefully, and stay tuned to Los Angeles Magazine, both in print and here on YouTube, for further analysis as the trial goes on. Thank you guys both very much for your time.
Gary, you're the best. Thank you so much.
Thanks, Gary. Bye.
Bye-bye.